Hello, my name is Douglas Chandler. I'm the founder and managing member of Chandler Law in Alpharetta, Georgia. Our team of lawyers and staff provide life and legacy planning services and professional liability and ethics defense for clients throughout the state of Georgia. Each of our lawyers have over 20 years of legal experience, and we bring that experience to every client we serve. I began my legal career at a boutique law firm in downtown Atlanta that handled professional malpractice and estate litigation cases. And although I was a newly minted first-year lawyer, I had the privilege of representing 26 heirs who lost their family farm, the family home place, and many of the family's heirlooms to an unscrupulous neighbor who exerted undue influence over the heir's elderly relative to get the relative to change her last will and testament. We were successful on appeal to the Georgia Supreme Court. That case taught me some hard lessons about how families need to have thorough and proper life and legacy planning in place to protect themselves, their hard-earned assets, and their loved ones. The lessons were particularly hard to swallow because, sadly, on retrial, after our Supreme Court victory, the jury overturned the award and the farm and the house and awarded the heirlooms to the neighbor, not the heirs. Today, we're going to discuss several things about our practice and our process that make our firm different from other estate planning firms. Chandler Law is the best fit for people who don't just want to leave their family a set of documents that may or may not work, but instead want to use the life and legacy planning process to pass on a legacy of love and care, thereby keeping their family out of court and out of conflict. We're glad you joined us today for this webinar, and we hope that it will answer your initial questions and encourages you to work with us to protect the life and legacy that you have created for your family. And once the webinar concludes, please take some time to review the helpful material on our website and schedule a free 15-minute call with us. But more about that later. Who is this presentation for? Well, this presentation is for you if you want to make sure that you aren't going to leave a mess for the people you love, and you want to ensure that what you do leave is full of clarity, love, and a future full of possibility and care. Before we begin, I'd like to ask you to ask yourself a question. Why did you come today? Obviously, you have some concern and you're collecting information to take some sort of affirmative action. Well, welcome. You're headed in the right direction. But let's get curious and ask ourselves why. Did you come here to have the total assurance and comfort of knowing your family would be taken care of? Did you come here to learn how to make arrangements so that your family would know what to do when, not if, something happens to you? Did you come for the peace of mind of knowing what would happen to your assets at your death? Did you come to find out how to make sure your family doesn't pay estate taxes unnecessarily? Or maybe you came to make sure you'd be taken care of in the best way possible and that the decisions would be made for you if you became incapacitated. If you came for any of those reasons, you came for the right reasons, because today you will learn what you need to have the peace of mind of knowing you've made the right decisions for yourself and your family during your lifetime, so that at your incapacity or death, it will be as easy as possible for the people you love the most. But the real reason I imagine you came is because you really care about the people in your life. So take a moment right now and list in your own mind the names of the people you are doing this planning for. Who will come forward to handle things for you when something happens? Not who would you want, but who would it be on a practical level based on where you live, who lives near you, and who would be the first on the scene. Now let's talk about the estate plan you already do have. Either you've created a set of documents already, or the state has a plan for you. Either way, there is a plan for what happens when you become incapacitated or when you die. It just may not be the plan you want. And we'll look at that today so that you become clear. One way or another, you're going to leave today with clarity about your next steps for getting your affairs in order for yourself and the people you care about. Most estate plans, whether you do it yourself online or do it with a lawyer, is about planning for death. One of my mentor's father-in-laws had a plan like that, and you might too. He spent $3,000 with a reputable lawyer. He got a set of documents that he thought would keep his family out of court and having to deal with an ex-wife. He put them on a shelf and he never looked at them again. Then, a few years later, he died. And all of a sudden, the family was in court and dealing with the ex-wife. My friend thought for sure there must have been some sort of malpractice, but it wasn't. It was common practice. And in fact, a similar story happened to my family. About 15 years ago, we were going out of the country and realized we needed some estate planning documents in place to help us in case something happened to us while we were overseas. We had the plan done, we answered a few questions, and we signed the documents. We put them on a shelf, never looked at them again. Then life got in the way. We had changes to our family, and we considered whether or not those changes would affect our plan, and in fact they did affect our plan, and we had to redo our plan. However, here at Chandler Law, we do it differently. Our planning is not just about planning for death and putting in place a set of documents that you'll never look at again. Instead, we're helping you plan for life. We're guiding you through an educational process that begins with helping you get more financially organized than you have ever been before, so that none of your assets are lost to the State Department of Unclaimed Property or an unnecessary court process, and understanding your unique family dynamics and your budget so that we can help you choose the right plan for you. And then we make sure that your plan works throughout your life so that we can be there for your loved ones when you can't be. So let's review the state's estate plan for you. If you have no estate plan and you become incapacitated or die, the state has an estate plan for you, and it's called going to court so that a judge can appoint someone to make decisions for you or give your family access to your assets or to direct where your assets should go. This court process is called guardianship if you are incapacitated or probate if you died. The court decides where your money goes, and it may not be to whom you would choose or in what amounts you would choose. And in fact, court is very costly. There are attorney's fees and executor's fees, appraiser's fees, court filing fees, bond premiums, and creditor claims. I heard a story of a recent probate matter that had one piece of property valued at $1 million. The attorney's fees alone were almost $30,000, and $22,000 of those fees were statutory fees provided for by state law. The executor was entitled to another $22,000 in fees. These fees could have been avoided with a few $1,000s spent on some foundational estate planning. Probates today take a minimum of 12 to 18 months if there are no major obstacles or disputes. And during this time, your loved ones may not have access to your assets. Who would you rather have assets available to them immediately? Your creditors or your children? And the court process is also totally public, meaning anyone can go down to the courthouse and pull your court records to see what you own and who's getting it. This is the will of Jackie Onassis on the screen. Would you like to see the will of John Lennon, JFK Jr., Babe Ruth? How about Jerry Garcia? You could, because all of them went through the probate court process. Okay, my point here is that a will is public, and it doesn't avoid probate. When a will enters probate, it puts all of the creditors out there on notice that your loved ones will be receiving money. The only plan that is private, avoids probate, and ensures your children receive your assets when you want and how you want, and can save you substantial estate taxes with a properly funded trust. But we'll talk more about that later. For now, if you want to make sure your family stays out of court, say to yourself right now, I want to keep my family out of court. Finally, and worst of all, your children would be entitled to all of your assets outright without any restriction whatsoever at age 18. A friend of mine's husband received about $50,000 when he was 18 and another $150,000 when he was 21. As a result, he didn't graduate from college until he was over 30 years old and never really learned to support himself financially. If you have minor children at home and you want to make sure that they do not receive what you are leaving behind at the age of 18, please say to yourself or make a note, I need to make sure my kids don't inherit money at 18. And one last piece. You may want to ensure that your kids receive their inheritance protected from lawsuits against them, protected from future creditors, or even a future divorce. For example, when a friend of mine got married and her dad died, he left her a small inheritance of $50,000, and because it came outright to her and she didn't know how to keep it separate, as most people don't, when she got divorced, her husband got half of its value. If her father had left her that money in a protected trust, she could have used it to invest in the family business or real estate and kept all of it when she got divorced. If you want to ensure that your children's inheritance is protected from lawsuits, creditors, or a future divorce, no matter how old they are, please make a note of that right now. Before we move on from talking about your kids, if you do have minor kids at home, I want to tell you two quick stories that could illustrate where your kids are at risk, even if you've already named guardians in a will. If you've not named guardians at all, as 69% of parents haven't, and something happens to you, the choice about who raises your kids will be left to a judge to decide. Several years ago, I heard about a family, the Barber family, 2 parents and 3 sons. They went on vacation in Arizona. They were from California. While there, they were in a car accident and both parents died. The boys lived, and when the authorities finally found a family member to come pick them up, they found one of the sisters of the mom. And that sister decided that she should get custody of the kids and their money and prevented them from seeing any of the other family members. After more than $100,000 of court costs and nearly a year of litigation and a huge family fight, a judge finally decided that a different sister should raise the boys and appointed a financial conservator over the boys' inheritance left behind to the tune of $100 an hour, and the boys will receive what is left over at age 18. If you want to ensure that the people you choose raise your kids in the way you want, no matter what, make a note to yourself right now. I need to name guardians. Even if you have a will naming guardians, your kids could be at risk. My colleague realized that when she was out to dinner with her husband and her baby daughter was home with their 16-year-old babysitter, my friend realized that she had named guardians, but they lived all the way across the country and no one would ever be able to find her will anyway. At that point, she realized that the authorities would have no choice but to take her daughter out of her home and put her into the care of strangers until they could find her will, locate her named guardians, and then they can make their way across the country. Because this was not acceptable to her, she created something called a Kids Protection Plan that ensures no kids are at risk ever from that happening by filling in the gaps left by a will-only plan. If you want to make sure that your kids are never taken into the care of strangers, mark down in your notes that you need to keep or you need to get a kids protection plan. And the other reason you may want to mark that down is if there is anyone in your life you would never want raising your children. A will does not exclude anyone from guardianship. And if you know you would never want a specific person raising your children or challenging your choices, you'll also want a kids protection plan. So mark that down in your notes. I need a kids protection plan. Now, we've talked a bit about what would happen to your kids if you have minor kids, and to your financial assets if you become incapacitated during your lifetime or when you die. But what about what happens to you if you become incapacitated? We all remember the Terry Schiavo story. These terrible sorts of events could have been avoided if Terry had properly executed a simple document. Now, many of you have executed such a document, but I can guarantee that for many of you, it's out of date and it won't work when you need it to. And it's unlikely to be comprehensive enough, providing detailed guidance on how you want to be cared for in the event you become incapacitated. If you want to make sure your choices are comprehensive and honored at your incapacity, if you have specific wishes for how you want medical decisions made for you, mark in your notes right now on your notepad or on your phone, I need to update or review my healthcare directive. Many people think they can avoid all of this by either owning property jointly, designating a beneficiary for their assets, or simply signing a will. Joint ownership has many problems. If you remember when you were in escrow on your home, you probably remember that the escrow agent asked you how you wanted to take title to your home. If you were single, you said just in your own name. If you're married, you probably said as joint tenants or something similar. If you said to take property as joint tenants, you have the benefit of avoiding probate upon the death of the first of you to die. But the downside is that you can't ensure the surviving joint tenant won't give all the property away to a future spouse or lose the property and assets to creditors. And you lose the benefit of erasing all of the built-in gain on the property upon death. Designating a beneficiary is an option where assets permit it, but many assets don't permit beneficiary designations. And where you designate a beneficiary, the beneficiary has unlimited control over the assets. Worst of all, naming a minor as a beneficiary just ensures that your insurance or retirement account will end up in court if you die before your children are 18 years old. And as we've talked about, signing a will not work either. The only way to keep your family out of court, either in the event of your death or your incapacity, is to have a fully funded living trust. This means that you've got a trust prepared that is properly custom drafted for your family to say exactly what you want to happen to your assets in the event of your incapacity or death, and all your assets are owned in the name of your trust. If you already have a trust, chances are it hasn't been updated since you created it, and it's likely out of date because your life has changed. The law has changed, and certainly your assets have changed. It's also very likely that your assets are not even properly owned in the name of the trust. If you have an existing trust, mark down on your notepad or in your phone that you need your trust reviewed and your assets looked at. When you create a trust, You get to choose how to distribute your assets to your heirs. They don't just receive assets at age 18, but instead according to a schedule that you determine. Most trusts distribute assets to their beneficiaries at ages or stages. For example, 1/3 at age 25, 1/2 of the remainder at age 30, and the remaining balance at 35, or 1/2 upon graduation from college, and the balance upon graduation from graduate school. This is an acceptable way to plan, but there's even a better way. How many of you would like to own assets that can never be touched by creditors, will never be subject to estate taxes, and can never be taken away in the event of a divorce? Yes, of course, we'd all like that. Now, what if I said that I could give you all this, but you couldn't control those assets? Well, you'd be a little less interested, wouldn't you? And well, in our living trust, you can give your children assets that can never be touched by creditors, will never be subject to estate tax, and can never be taken away in the event of a divorce, and you can give them complete control. These are cutting-edge techniques that only the most knowledgeable estate planning attorneys are taking advantage of, and I know you want to include them in your plan. If you want to protect your kids' inheritance, make sure you mark down in your phone or on your notepad, if you haven't already, I want to protect my kids' inheritance. Now this won't apply to many of you, but just in case any of you do have assets in excess of $13.61 million individually, or are expecting an inheritance that could put you in that category, you need to know that your family could lose nearly half of all your assets in excess of that, even if you receive it by inheritance. To whom? The government. I won't spend a lot of time on that now, but if that's you, you need to mark on your notepad or your phone, I need to avoid estate tax. Finally, the last thing I want to mention here that does apply to all of you is that there are currently $2.9 billion in Georgia's Department of Unclaimed Property. And most of that got there because someone died and their family overlooked an insurance policy or a bank account or an investment or retirement account. This has happened to lawyers in our office, and it could easily happen to you if you do not get financially organized and make sure your family knows what you have in the event of your death or incapacity. Think about it for a minute and consider if you didn't make it home today. Who would know how to find what you have? Where is it? And how to access that information? What would be lost forever because no one even knows it exists? Take a minute right here and write down the list of things that you know no one knows about. Crypto accounts, bank accounts, insurance policies, retirement accounts, that family heirloom. Where are they and who would know how to find them? If you aren't clear, make another note on your notepad or your phone. I need to create an asset inventory. The last thing I want to talk with you about is this. If you had to choose between the people you love receiving their money or your values, insights, stories, and experiences, what would you choose? Most people say if they had to choose, they would choose their non-monetary assets, their intellectual assets, their spiritual and human capital. So it makes no sense that most estate plans completely ignore that altogether. When my mother passed away, her estate was handled pretty smoothly. Several months after she passed away, we discovered a recording on our home voicemail machine where she addressed the children. That simple recording of her voice addressing the children and saying that she would call back again was a treasured asset for the children. How many of you would like to have your intellectual, spiritual, and human non-monetary assets preserved? We can do that for you. So, we now know what doesn't work. Doing nothing doesn't work. Having a will only doesn't work. Or even getting an estate plan created by a lawyer who just focuses on documents does not ensure the protection of your kids or your assets, doesn't ensure your assets are owned in the right way, and who will take care of things when something happens to you, doesn't keep your assets out of court or out of the Department of Unclaimed Property, and very likely could leave your family unnecessarily at risk of a big mess in the event of your incapacity or when you die. And here's the other thing. What you need is different than what any other family needs because your family dynamics are unique to you. Your assets are unique to you. And the law as it applies to your family dynamics and your assets are specific to your circumstances. I will say it is possible that one size fits all or even do-it-yourself planning could make sense for you. And I'll share some details on that in a few minutes. That's why we begin all of our planning with a 2-hour working session. Sometimes we break that into 2 one-hour sessions, but what we call it is the life and legacy planning session. But either way, it's the same process, and it's a process our clients love, and you will too because you'll feel so good about your choices after it. Really understand all of your options and actually get your planning done the right way and know you have a plan that works at the right price for you and your family. The life and legacy planning session process begins with an inventory of your assets, which you need no matter what to ensure that when something happens to you, your family knows what there is, where it is, how to find it. Otherwise, your assets are at risk of being lost or your family is left with a big mess. So we'll support you to create an inventory of your assets, and then we'll have a 2-hour working meeting or perhaps 2 one-hour meetings that support you to make informed, empowered decisions for the people you love so that you know what exactly you need to have in place and what you don't. And during that meeting, we'll get to know your family dynamics and your assets, and you'll get to know enough of the law to choose the right plan for your family at the right budget so you've chosen the most affordable route for you and the people you love. So you're likely wondering what all this costs. The regular cost for a life and legacy planning session is $750, but in a moment I'll tell you how to get it for free. Our average fees for planning run between $2,000 and $8,000, depending on your family dynamics and your assets. But what's most important is that you choose your fee during the life and legacy planning session, and by the end of our time together, you'll know with certainty you are making the best decisions throughout your life, and your family will know how much you cared about them and loved them in the event of your incapacity or death, because everything will be so well handled. We'll guide you through every step of the way. Ultimately, this is something you do for the people you love. And we've designed the entire process to be as easy as possible for you and to support you to actually do the right thing, the thing you want to do for yourself and the people you love. Procrastination is the biggest risk to your family. Hear me again. Procrastination is the biggest risk to your family. So here's what we're going to do. If you schedule your life and legacy planning session today and commit to completing an inventory of what you own and what's most important to you before your scheduled appointment and turning it into us 3 days before so we can review it, we will waive this. Restart here. Ultimately, this is something you do for the people you love, and we've designed the entire process to be as easy as possible for you. and to support you to actually do the right thing, the thing you want to do for yourself and the people you love. Procrastination is the biggest risk to your family. Hear me again. Procrastination is the biggest risk to your family. So here's what we're going to do. If you schedule your life and legacy planning session today and commit to completing an inventory of what you own and what's most important to you before your scheduled appointment, and turning that inventory in at least 3 days before so we can review it, we will waive the $750 life and legacy planning session fee. But I'll also credit you $250 towards your planning. That's a $1,000 gift of services to inspire and encourage you to do what you came here to do today anyway. So here's how you claim your golden ticket in 3 simple steps. Step 1, go to our website, chandlerestatelaw.com. Step 2, once on the website homepage, find the blue button, Schedule Online, at the top right of the screen, which will take you to the Schedule Online page. Step 3, on the Schedule Online page, click the Schedule 15-minute call blue button. On the calendar provided, choose a date and time for your free 15-minute call with Britt Chandler. On that call, Britt will let you know the next steps and will schedule your life and legacy planning session. When you take these 3 simple steps and schedule your life and legacy planning session with Britt, commit to completing the inventory on what you own and what's most important to you before your scheduled appointment, and turn it in 3 days before the planning session so that we can review it, we will waive the $750 life and legacy planning session fee, but I'll also credit you $250 towards your planning. Again, that's a $1,000 gift of services to you. Okay, so if you're still sitting there and wondering whether you really need to come in and meet with us for a life and legacy planning session, or if you're wondering if you can just do this all on your own, let me help you get some clarity so that you know what to do next. You can create your own legal documents. You do not need to meet with us for a life and legacy planning session if you don't have anything that would go through the court process when something happens to you. If you're 100% clear on who you want to handle things for you and there's no complications, you can list 3 people you want making healthcare decisions for you, financial decisions for you, and to take care of your kids for you if you have any and all if you have any and they all live close and won't fight or argue. If you're naturally organized and get it done, all you need to do, you know what all you need to do, and you'll do it. If that's you, then we invite you to visit the Chandler website, Schedule Online page, and send us a confidential message regarding your circumstances, and we'll send you some free information to help you. Again, what are your next steps? Complete your notes from today's webinar. Schedule your free 15-minute call with Britt today and receive your $1,000 golden ticket, including a certificate for $250 towards any planning you decide to do with us. And then use your $1,000 gift and ensure a lifetime of protection for your family and your wealth. And get excited to complete your homework so that your family isn't in the dark about your assets and when something happens to you. We want to thank you for tuning in to this webinar today. We hope it's been informative for you, and we look forward to hearing from you so that we can help you and your family and those you love the most. Thank you.